Top story, the bill to amend the constitution to allow for land expropriation has failed. The ANC failed to get the two-thirds majority it required to pass the amendment. Most opposition parties rejected it, saying it was not necessary. Head and Director of Land Reform Restitution at Werksmans Attorneys, Bulelwa Mabasa, joins me now from Pretoria for more reaction on this. Bulelwa, thank you so much for joining us this evening. Let's get, we want your legal expertise here for a second. And let's go back to the drawing board, or right back to the start. What does Section 25 actually deal with?
Thank you for having me. Section 25 is contained in the Constitution's Bill of Rights, and it deals with three important concepts. The first one, Section 25(1), deals with the fact that property landowners or current landowners may not be deprived of their property or land unless is by a law of general application, which means there has to be a statute that governs how land can be deprived from people that are current landowners. So that's the first concept. The second concept is that it deals with when land is expropriated. So in other words, where the state has a need for a piece of land or property for a public purpose or a public interest, it sets out conditions or factors that must be taken into account when compensation for that expropriation happens. It's important to pause here to say that expropriation as a legal concept is something that has pre-existed even the Constitution and the pre-democratic era itself. We have current legislation that was promulgated in 1975, and the simplistic way of explaining what an expropriation is, it's that this is a power that a state has once it's identified land, to acquire that land from any person for purposes of building schools, clinics, or anything that is considered to be a public purpose. And land reform is part of what that purpose could be as a public interest issue. Now, the concept by definition is intrinsically linked with compensation. And this is a concept that has been developed throughout time from Roman Dutch law, Canada, Germany, and so forth. So the concept of expropriation being intrinsically linked with compensation is what we have inherited in our law, and that is what our Constitution provides for. Our Constitution, though, unlike other jurisdictions, does not make provision for expropriation to be paid by way of market, willing seller, willing buyer. What that means is that our Constitution recognizes that the state could still expropriate at prices that are much lesser than market value. And then lastly, it also deals with those provisions within the Constitution that are transformative, that are looking ahead, where the state is also given the mandate to ensure that it can deliver on its land reform objectives. So I think that's one way to kind of summarize it in a crisp way.
So to a certain extent, it gives the state certain tools in order to carry out the mandate of restitution, redistribution, and reform, correct? But the ANC wanted to amend the Constitution so we have expropriation without compensation. Who would have benefited the most here?
Look, I think it's important to turn back the clock a little bit and say the 2017 ANC National Conference in Bulelwa was when the first resolution of the ANC was taken in order to deal with, or in order to make it possible for expropriation to happen without compensation. And the ANC, that was its resolution in Bulelwa. That the ANC was then overtaken by the EFF about 2 months later, when the EFF then led the motion to put to Parliament that expropriation, to have a constitutional amendment for expropriation to compensate for compensation. So I think it's important to realize that there is a political arena here where the ANC had envisioned a certain way of expropriation without compensation to happen, not as a wholesale concept, but rather something that could happen in specific circumstances. On the other hand, the EFF position has been a wholesale nationalization of land. And you ask the question, who stands to benefit? Well, if I think there are a couple of things. The first is that Section 25 is not the most clear in the sense that even within legal circles, there's been debates around whether or not it allows for zero compensation or not. We don't have legal jurisprudence or courts assisting with an appropriate interpretation on whether or not expropriation without compensation could happen. But where we sit today, we know for a fact that expropriation can happen at less than market value. So I don't think the question we should be asking ourselves is really, who stands to benefit. I think the question we should be asking ourselves is whether or not the solutions and the issues that have dogged the land reform program will come from a constitutional amendment. And I think this is where we should be saying, what can the state do currently with or without the constitutional amendment? What tools does the state have in its control? What policies are there that should be implemented that are not implemented? So I don't think that the amending a constitution in Section 25 is going to lead to the whole scale resolution of the land reform agenda in
Bulelwa,
general.
it sounds like you're agreeing with some of the arguments that were put forward a little today in Parliament, that the Section 25 already gives the state enough tools to to enact some of these what we're talking about here, redistribution and reform and so forth. Where has the state failed?
I think firstly, the state has failed in continuing with a land tenure system that is dualistic. What do I mean by that? I mean, for the large black majority that are living in informal settlements, informal shack dwellers, backroom, people that live in back rooms, and of course the landless. And if you also take people that live in communal, traditional areas, we have an overwhelming majority of the black population that does not enjoy legally recognized rights. They do not enjoy legally registrable rights that can actually give them a stake in the whole land reform discussion. So the first issue is that we have not streamlined the tenure system in South Africa to ensure that whether you are black, white, poor, or wealthy, you have a stake in the sense that you have a right that can be made provision for in a deed registry. That for me is one of the biggest failures, and we've carried this dualistic differential forms of tenure from the apartheid government, and we haven't done much to streamline it so that the black majority can also become stakeholders within land reform. And I think, secondly, the Constitution itself has directed the state to take legislative measures to ensure that there is redistribution and access to land. To date, the state has failed to introduce legislation that will ensure that those that need land have a statute that tells us who must benefit from the land, where must that land come from, and from what purpose. So to my mind, that would have been the most immediate lacuna and an immediate issue that the state should be tasked with the redistribution area, because redistribution is a low-hanging fruit, because it doesn't need anyone to prove a pre-existing claim, a historical claim. It needs a legislative framework that says, yes, we recognize that women are the ones that need land, the youth are the ones that need land, and that land is actually needed in our urban centers so that people can be close to economic nodes, that they can be able to access economic opportunities
Bulelwa,
especially given the
you mentioned the economy. Our economy is tanking a little bit at the present moment. Well, maybe a little bit. I'm being kind here. But you've got the issue of land. You're talking about the urban areas. You've also got private developers. You've got large-scale farmers and so forth. I'm sure you have many of your clients coming to you talking about the uncertainty. Do I invest? What do I do? Because I'm not too sure what's going on here.
Yes, so I think there is benefit in clarifying circumstances that will apply when there's expropriation without compensation. Unfortunately, that is not what the constitutional amendment is going to do. That is not what the process in Parliament is going to achieve. Where that needs to be achieved is by having an expropriation bill, an expropriation act that will breathe certainty, legal certainty to potential investors, so the investors are aware of what to expect when they make capital improvements and when they invest in their country. There should be legal certainty around when does expropriation happen, and where there is objections, that they do have access to the courts to be the final arbiter on the amounts of compensation. So really, to my mind, the constitutional amendment is not going to be the one place where all the solutions from land reform are going to come from. Where the solutions for land reform are going to come from is from ensuring that with the restitution program we have, it is funded, it's well resourced, and that we have officials that are resourced and skilled enough to push through the restitution agenda. And with redistribution, make sure that you have passed a redistribution bill that is clear, that is certain, and not rely on internal policies that have not been tested in Parliament. For example, with the redistribution program, for the last 27 years, depending on which minister is on the helm, we have had policies that have been chopped and changing. Some have been pro-poor, others have been more about emerging farmers, and where we've actually seen that women have actually been the least recipients of redistribution projects. So this is a place for me to say, once we have a redistribution act, this is where we're going to see results that are tangible, and a piece of legislation that is capable of being implemented.
All right, thank you so much for your wisdom and your legal expertise there. Bulelwa Mabasa, Head and Director of Land Reform Restitution, saying that amending the Constitution is not the panacea. Okay, let's move.